The next speakers are lawyers, and they're going to share with us some of the legal work that has been done in this area. I sort of gave them a backhanded mention in the op-ed in the Wall Street Journal without actually mentioning them. I'm sorry. Next time I will give you the props that you deserve for carrying the water for this issue legally. I'm going to invite both Naomi Lopez Bauman and Jim Manley up here, sit up here. You'll both have an opportunity to tag team this, but they are from the Goldwater Institute. They've been working in this area for quite some time. Naomi is the director of healthcare policy for the Goldwater Institute. Jim Manley is one of the senior attorneys. He's a litigator. He's been really in the trenches working on this, and I love the personal statements. I gotta get Jim to take me out skiing one time. He was a ski instructor before he decided to give up the good life and become a lawyer. So without any further ado, let me introduce Naomi and Jim and have them take it from here. Go ahead.
Thank you so much for having us today and for hosting this really important topic. But I will have to point out, I don't want my name disparaged or my reputation. I'm not a lawyer. So the Goldwater Institute is a public policy organization. We do policy work, but we also do litigation. So we're able to act very strategically whenever we want to push a reform or partner with one of our liberty partners in the states. We have 50 states across the nation, and we really do believe in the principle of federalism. And we operate from a perspective that the federal Constitution does protect liberties, but it is a floor, not a ceiling on individual liberty. And we can actually go into the states where state constitutions in all cases actually go above and beyond those federal protections. And that is how we think about policy, and that is how we strategize about it. So whenever we're taking a look at certificate of need laws, it's important to know that while there is a federal constitution, we also have 20 state constitutions that have anti-monopoly clauses. And take a look and see if your state is one of those states, because that can offer you a really important opportunity for reform that you may not have already been thinking about. And it's another tool in your arsenal to battle against the certificate of need laws. So like I said, the Goldwater Institute uses state constitutions, we use the capitals, we use the courtrooms to legislate and litigate for healthcare freedom in a number of areas. And one of those areas is certainly supply-side healthcare, and under that umbrella, increasing the supply of healthcare providers and facilities is one of those central issues. And that is why we engage on the certificate of need issue around the country. Now, whenever we've been engaging in the past, I'd say past year or so, when this issue has really been heating up, I've come across, I've come across an area where I think our movement is going to need to focus more time and energy on, and that's the issue of spending, in other words, healthcare utilization versus the actual cost of those services. And there's been such important groundbreaking work done by the Mercatus Center. We're building on that just a little bit, and we're looking at actual healthcare costs. We're looking at two specific areas where there's good data, and really so far the big obstacle to having more of this type of work has been a lack of data. But we are using nursing home and home health care data to take a look at what the actual cost of providing that care is. We all know that the Affordable Care Act never did reduce healthcare costs. This is what lawmakers today, I think at the state level, are really concerned about. This is what they think about. And I think that one of the opportunities is to talk about how they can move forward, across the political aisle and actually address the unmet goals of the Affordable Care Act and actually help reduce the cost of providing that care. So what we're taking a look at is, what we're doing is we're taking metropolitan statistical areas that have more than 1 million people. We're also taking a look at the demographics and also the health coverage compositions of those populations and trying to do an apples to apples comparisons of what it costs to have semi-private or private care in a nursing home in con versus non-con cities, and also home health care. And so we're very early in our work. We've done some work, but we still have an enormous amount of work to do, and we're still months away from actually having a published product. But I do want to let you guys know that if this is an issue that you want to look at, if you've got cons in these two specific areas, and actually even if you have them outside these areas, I think it is an opportunity to provide a really good look at, asking lawmakers, why are you allowing our seniors, our elderly population, that vulnerable population where finances are always a top concern, why are you allowing them to pay more than the neighbors to protect a cartel? So, like I said, we're looking at a number of different variables. We are looking at several different cities across the country, and we're dividing them by population. That work I would expect would be out late fall, but also we can package something for you in your state if you're interested in working on that in that sooner, and certainly for the 2018 session. But with that, I would like to introduce my colleague, our senior attorney, Jim Manley, who is an amazing litigator. He is he's very committed to liberty, and he's going to talk to you today about his case challenging the certificate of need law in the state of Georgia.
You pay them to do all these Georgia things.
It's ground zero. What can I say?
Yeah. I don't know if it's really a compliment to Georgia, but thanks, Naomi, and thanks, Hal, for putting this together. It's essential, and I'm glad we're doing it. I'm glad everyone is here and fired up about fixing these terrible laws. We got turned on to this issue. We've been studying CON for a long time, and when we came across Stephen Calabresi's article, he published it maybe 2 or 3 years ago in the Harvard Journal of Law and Public Policy, sort of surveying the anti-monopoly clauses across the country. And there are clauses in the state constitutions, they're anti-monopoly clauses, they're privileges or immunities clauses that essentially protect the citizens of the states from anti-competitive laws. And so we started focusing on some of the states that have actually enforced these provisions of their constitution. And Georgia is actually one of the states where the courts have taken these protections seriously. And the Georgia Supreme Court has actually struck down a monopoly that favors one of the most well-connected industries, probably more well-connected than the hospital monopoly, the auto dealer monopoly. And so with that precedent in mind, we focused on Georgia and trying to find doctors who were interested in challenging these anti-competitive laws, who were being prevented from providing care to patients because it would eat into the revenues of competing hospitals. Of course, there's an unhappy footnote to that auto dealer story. The auto dealers are so strong that they got a constitutional amendment to exempt them from the anti-monopoly clause. And so you do still have monopolies for auto dealers in Georgia. But Georgia also has strong due process clause protections, which provide protections against irrational and anti-competitive restrictions on the right to earn a living. And so the Georgia Supreme Court has struck down laws regulating the milk industry or the gasoline industry to try to control prices. Exactly the same sort of regulations or same motivation that leads to certificate of need laws, to try to manipulate the price of health care through anti-competitive restrictions. And the Georgia Supreme Court has said, no, our Constitution does not allow that approach to economic regulation. And so we've taken both of those clauses of the Georgia Constitution and used them to fight back against the con laws. We've also brought claims under the federal Constitution, but as I'm sure we'll discuss a little bit later, it's much more difficult to win a case under the federal Constitution because the Supreme Court has drained a lot of the meaning out of those protections. There are folks that have been successful in fighting con under the federal Constitution, including my colleague Tim Sandifer, who struck down moving company certificate of need laws, of all things. And I know IJ and PLF are still fighting that fight as well in the federal courts. But what I really want to key your attention into today is the protections in the state constitutions, which I know IJ and PLF are also focused on. Now, we call these certificate of need laws sometimes competitors' veto laws, and in Georgia, they truly are a competitor's veto. What we found in looking at the data that we were able to uncover through litigation was that con applications that are unopposed are overwhelmingly granted. So if your competitors don't object to your application, you typically get it. But if a competitor opposes your application, the opposite is true. Their opposed applications are overwhelmingly denied. So the hospitals are incredibly strong in this area. Even separate and apart from their ability to influence legislators, they have an apparent ability to influence the regulators as well. The Hospital Association tried to get involved in our lawsuit, in fact, in order to protect their monopoly. And they were quite upfront about this. They said that if the con laws are struck down, our members will lose revenue. And we won't be able to protect against cherry picking, which in ordinary language just means competition. But that's what they said they wanted. That's the interest that they wanted to protect by getting involved in our lawsuit. And we fought them on this and frankly expected to lose. But our trial judge saw that attempt for what it was, which was an attempt to maintain their monopoly. And quite tellingly, the judge said, no, you cannot get involved in the lawsuit as a party. You cannot intervene because your interest in maintaining your monopoly is the same as the state's interest in maintaining the con laws. And I think that tells you all you need to know about what the real purpose of con laws are. Now, we were also able to take advantage of Dr. Strautman's research, and he served as an expert witness for us and offered a tremendous rebuttal of the idea that con laws serve any valuable purpose, and produced a report for us that demonstrated that con laws lead to less competition and all the predictable results of less competition that he summarized before: less care, higher cost, less access to care, and lower quality. Now, in Georgia, the limits on ambulatory surgery centers are quite severe. Our clients, Dr. Rebo is here today, and he's that one on that side. And then his partners there have an ambulatory surgery center in Georgia. They are OBGYNs. They provide really amazing laparoscopic surgery services. I was blown away by the sorts of things they're able to do in an outpatient setting, including hysterectomy, which is just fascinating to me. And they have a tremendous track record of success in terms of zero infections, incredible rate of success in their operations. And they're able to offer these services at a lower cost in a nicer environment than the hospital across the street. And of course, all of that led the hospital across the street to object when they applied for a CON to expand their practice. And they wanted to add another operating room. They wanted to be able to sell shares to other doctors, and they wanted to be able to let other doctors use the operating room when it sat empty when they're attending to the rest of their practice. And it's really that last piece that strikes me as particularly anti-competitive, because the CON laws allow them to hire as many full-time employees as they like. But if they want to let a doctor use their facility, they can't do that. Now, CON-approved operating rooms don't face that limitation. And so what that does, and what the only thing that it does, is prevent ambulatory surgery centers from competing with CON-approved operating rooms like the one in the hospital across the street. And so the hospital across the street and a couple of others objected to their CON application, and it was denied. And so we filed suit using those provisions of the Georgia Constitution and the federal Constitution. And I'm happy to say, well, I'm unhappy to say that we lost at the trial court, but I'm happy to say that we are now in front of the Georgia Supreme Court. And in 10 days, we'll be arguing our case there. And with any luck, we will get the same outcome that the auto dealer monopoly received in the 1970s, which is to have the con laws wiped off the books and free and open competition returned to the Georgia healthcare market. And I think if we have a couple of minutes, I'd like to ask Hugo to come up and explain to us why they thought it was worthwhile taking on this fight. In all of our cases, we have to have a plaintiff, and it's not a small thing to put your name on a lawsuit to fight against the people that have the power of life and death over your business, to put your name out there in your community as someone who's standing up to the status quo. And so I am always grateful for our plaintiffs, because they're really taking on a task that benefits many more people than just themselves. And it's a tremendous burden to take on. And I wanted him to talk to you a little bit about what this looks like from the ground up, and to understand what his motivation was for bringing this suit. And I think you'll find it interesting.
While he's coming up, let me just ask you a question, Jim. How much of a game changer would this be to have this domino fall?
Oh, well, it would be tremendous, because very few states have legislatively repealed their con laws since the 1980s. And then we know why that is, because there's a tremendous lobby fighting against it, and the people who are hurt by it are the rest of the people in the state. Concentrated benefits, dispersed costs. And so to have a court say that this system is unconstitutional, that this system is expressly anti-competitive, would be tremendous.
So, thank you for letting me get up here. This is not my thing, public speaking, but I met one of the attorneys who, well, I don't think he's with your institute anymore with Goldwater, but he's on the Supreme Court of Arizona now, Clint Bullock, at the Conservative Policy Leadership Institute that I took part in Georgia, and just started talking to him about what we were doing and what we could do and what we couldn't do. And he's the one who contacted Goldwater and led to all this. What we were applying for, we weren't even applying for a true certificate of need, which a full-fledged certificate of need in our state lets you have multi-specialty expansion and different specialties: GI, plastics, general surgery, urology. All we were actually applying for was what they call a single specialty CON, which is still restricted to gynecology only. So we weren't going to try to open up a mini hospital and try to siphon patients in large volumes away from our local hospital across the parking lot. And because we knew several docs in the community who were looking for places to do outpatient surgery. One example that comes to mind is a colleague in a town 20 minutes from us is a very high-volume specialist in, I'm sure people have heard of lawsuits regarding pelvic mesh procedures. I don't know, people look around and they say, oh, everywhere you turn, have you been injured by pelvic floor reconstruction mesh, vaginal mesh, et cetera. And this particular one doc has been going all over North Georgia trying to find a place where he can do these cases, because they're not covered by insurance. And there's very few doctors who have the skill to go back in and try to remove part or all of the mesh in these ladies who've been injured by this product. And he has been all over the place trying to get a place that's not going to fleece him and his patients in terms of facility fees. And he's been, one of the several docs who've been practically begging to use our facility. And we researched every possible way that we could let him operate there, but we'd be subject to pretty harsh penalty. I think you guys tried to look at what kind of penalties we'd get.